and I just wanted to get a few of you online already. It looks like we already have 50 attendees that have registered and are already signed up and listening in. So to all of you out there, welcome to, I guess this is our third of the year webinar in our webinar series for the Upchurch, Watson, White, and Max webinar series. That beep that you just heard was me violating my own rule about having something open on my computer that shouldn't have been. I can't believe I did that. What do I have open? I have my inbox open. No longer. Okay. We are at noon exactly, so we're going to go ahead and begin. Let's see, we're recording, so we are good to go. So welcome, everybody. We are here today at our third in 2014 of our Upchurch, Watson, White, and Max webinar series. We are co-presenting today with the University of Florida Levin College of Law Institute for Dispute Resolution, as we always do. We really honor our relationship with them and look forward to our monthly offerings. Like I said, today we are going to be discussing with you bringing class actions and mass claims to resolution. We have quite a panel of presenters today. We have Rodney Max, partner and principal with Upchurch, Watson, White, and Max. I learned from watching him and his mediations, and I'm so honored to be one of the panelists at Upchurch, Watson, White, and Max under his tutelage. We also have with us today Steven Brodie, who will be sharing the defense side of class actions and mass claims. He is a shareholder with Carlton Fields here in the lovely state of Florida, and you're in Miami, so hopefully it's nice and warm down there. It's a little chilly up here in Daytona. And we also have with us John Yanchunis, who is with Morgan & Morgan, who does the plaintiff side of class action and mass claims work. And John, you know me and my family, I believe, from Clearwater. Is that correct?
Yes.
Okay, great. I remember talking with you at a bar meeting, and it was just a nice connection to have, an old family friend. So welcome, everybody. Like I said, today we're going to be discussing bringing mass actions and class actions to resolution. We have a panel that really needs no further introduction. So with that, I'm going to go through a couple technical issues. You should have on your screen a toolbar for GoToWebinar. If you don't want to see that, press the orange arrow that's facing off to the right, and that will eliminate that toolbar so you don't need to worry about it. We have had some questions presented in advance, and we will go ahead and take those questions on air. If you have additional questions that you would like the guys to answer, there is a questions section on that toolbar. So push the orange arrow that's facing to the left, and that questions section will pop up. We have a lot of material to cover today, so I cannot guarantee that we're going to get to that question, but I can promise you that Rod or John or Steve will get with you after the webinar sometime in the next few days and get that question answered for you. Lastly, try and maximize our PowerPoint screen so you can see the full view and not just a little half view. There should be a big screen in the right-hand side, top right-hand corner. You should be able to click on that to maximize what you're looking at. So without further ado, let's go ahead and dig right into bringing class action and mass claims to resolution. Good morning, gentlemen. How are you all doing today?
Doing fine, and thanks for helping us put this together, Sandy.
It's always a challenge making sure all the technology is working, and when the internet's working, the power is on, and GoToWebinar is up and running. It's a good day for me. So without further ado, we're going to go ahead and begin talking about the confidentiality of class actions and mass claims. And Rod, I'm going to turn it over to you and your distinguished panel to go ahead and take it from here.
Well, great, Sandy, and again, thank you. And it's a real honor to be joined by both Steve Brodie and John Yanchunis. These are the leaders of our field in class and mass actions from the respective side, and the opportunity to work with them both in mediations as well as in this seminar has been indeed an honor for me. We have a unique situation with class actions particularly, and mass actions as well, in that they're very much in the public eye. And I say that to say, you know, and the end result of a class action is court approval, which is very public. There are opportunities for people to question, as well as the judge to have to consider the approval thereof. And so the opportunities that we have in mediation are very important to use and utilize the confidentiality while we have it. And so from the moment we begin the process, and that's not just the day of mediation, as we'll be talking about pre-mediation, it begins when the mediation is commenced, is confirmed. When you've got a mediator and the mediator starts engaging, those conversations, those communications are confidential. Now when we get to hopefully resolution, then all of a sudden that becomes part of the public eye. But the opportunity to use confidentiality is a tool, is an opportunity to be used for good, to be used to be able to be candid, reasonable, to try to be able to work through things that would otherwise require a lot of posturing. John and Steve, I don't know how you see the use of confidentiality as we begin the process, but it seems to me as the mediator that not that I have to be involved in every one of your conversations, but if I can at least coordinate and facilitate it to initiate it, and then we go on through there. As most every mediation, I'll have a confidentiality agreement, and that says, okay, from start to finish, we are confidential with our discussions. Would you agree with that, or do you have a different thought with regard to confidentiality?
Clearly, confidentiality is an important hallmark of the mediation process. Both counsel and in-house counsel or the client representative who's participating in the process has to feel comfortable that there can be frank discussions, sharing of information that will be confidential, that will not be used adverse to the party in the event settlement's not reached, nor will it be used to disclose to make others aware of some decision-making matrix or issues that the parties may be discussing. So I think confidentiality, the process fails without a full confidentiality agreement and comfort that that will be upheld.
Very good. John, from your perspective?
It's the same, Rod. Sometimes the parties can even get a little nervous in connection with a public filing in a court file that a case is going on to mediation on a certain date. So I agree with Steve that the confidentiality of the process is paramount. Parties will exchange positions, sometimes to the level of acknowledgement of things that they would rather not have come out in litigation. So I found that to be much better. It allows for a free exchange of thoughts and comments and can more readily lead to resolution.
Well, I'll tell you what becomes important in using confidentiality and goes into the next portion where we talk about the foundation and the premises for class action and mass action mediations, and that is that we have to look towards a high level of professionalism. And when you have that on the plaintiff side and the defense side, you really need to capitalize on it. The idea of talking about not just strengths, but weaknesses. The idea of talking about areas of vulnerability, but areas that are important to the other side to understand. That is one of the foundations. I think the other is, and again, Sandy, you may want to turn to Roman numeral 2.
Sure.
That under B we have the interest-based negotiations. Many times when you're dealing with personal injury, wrongful death, or contract, real estate matters, they're really kind of meat and potatoes in terms of, okay, what's the number? But in class action and mass action negotiations and discussions, you've got a lot of interest-based negotiations that make, yes, as important as the rights are, it's the interests of the parties that have got to be met. And again, when confidentiality can pervade all that, then the interests can be put on the table so people can understand and acknowledge. And of course, the third item is, and it's the unique part, it doesn't happen in litigation, but it happens very much in mediation, and that is building trust and appreciating the mutuality of the process. If those are not respected, if somebody comes into a mediation, class action, mass action, saying it's my way or the highway, we usually find the highway. But if we can use mutuality and use the process of exchanging in the confidentiality of it, we build the trust, and then we understand that there are 2, 3, 4, or 5 sides to every story. And that's got to be recognized in order to achieve the ultimate resolution. And so from the foundation, we really get into what I call the pre-mediation. And Sandy, that's a Roman numeral 3, where this is where... Yes, Steve?
Rod, let me throw something out there for a sec.
Sure.
Carlton Field's Jorden Burt has conducted a class action survey. I think this is our 3rd year of the survey, which is one of the first of its kind, where we go out and interview corporate counsel to get their views and assessment towards class action. And we discovered that corporate counsel reported they spent $2.1 billion annually on class action lawsuits in 2012.
Wow.
And when we did this previously, one of the concerns in-house counsel had is, how do we reduce some of the costs associated with class action litigation? And in 2011, they indicated they wanted to kind of decrease costs. And one of the ways that they've actually achieved decreasing costs from $776,000 to $671 is by engaging in rigorous case assessment and modeling to calculate financial exposure early on in cases. And there's still a number, probably a third of in-house counsel would prefer to vigorously defend class actions, but there appears to be a mindset of over around 22% that feel that early assessment and mediation is a way to control costs. So I think this whole discussion about pre-mediation and the effect of mediation is important. It's really, I think, a key thing for defense counsel to understand your client's perspective on mediation, and if in fact they're prepared to engage in early on vigorous assessment of the both liability and risk and damage factors, that early mediation could be an effective tool of ultimately controlling costs of litigation.
Well, that's very interesting, Steve, and I'll say this, as we get into pre-mediation, to me that is such an important aspect of the mediation process, because by not only contacting the lawyers, but sometimes the lawyers say, you know what, it would be good to engage our clients in this. You know, this is their process. The idea of early evaluation, which is a theme that I think many successful corporations around the United States have been using in a lot of different venues, not just class and mass actions, but particularly when you're talking about a global resolution, whether that's statewide or national, to involve people early on to do what? We're talking about identifying the issues, you know, what's agreed and what's in dispute. And how do you take those items that are agreed, put them over the side? I usually try to say, let's build the bridge with those things we can agree on. Let's deal with the disputed items. Let's make them part of an agenda when we actually get to the table. To inquire of who the leaders are, and again, what those interests are. And many times I find that things can be done by telephone. They can be done by exchanging position statements. Sometimes they're done by actual meetings. I've had some where we have gone to Chicago for one meeting, and we've gone to Philadelphia for another meeting, and then we happen to come to the mediation. All that was done pre-mediation to get, you hear the concept, get to know me. Well, get to know the interest, who's involved, and why are they taking the positions they are. And that helps build an important part called rapport when you get to the table. And guys, you all are actively involved in pre-mediating, even before sometimes the mediator is selected, or certainly once the mediator is. How do you utilize the pre-mediation for issues and interests and trying to define the agenda once we get to the table? John?
Well, in connection with pre-mediation, where we've selected a mediator, Rod, which is really where the real work begins, is we tend to, or I tend to, try to do exactly what those 5 budget items on this screen are. It's so important in advance to get an idea of what's going to be on the table when you get to mediation, or you're going to end up with half or 3/4 of the day spent on simply bringing people up to speed, not just the parties, but also their representatives. So in advance, while we don't necessarily get agreement, we at least are able to define what we're talking about. And that includes sitting down with the mediator either on the phone or in person before the mediation session to educate the mediator what the case is about, whether we're dealing with a, the size of the class that's in question, the possibility of the different types of relief and potential roadblocks, so that the mediator, before he or she gets to the mediation, can begin to think and cogitate on those things that the mediator is going to have to address at the mediation. Are there personality disputes? Are there issues that are sensitive to a publicly held corporation? Are there other problems with seeking resolution of this dispute?
Mm-hmm. Steve, how does pre-mediation work for you from the defense side?
Well, 2 things. One is, I think it's important to kind of really understand the factual basis the plaintiffs are asserting. 2, I think it's important from the defense side to properly evaluate the legal strengths of some of the defenses you may have, including the ability, if there's, for example, arbitration provisions, which are in many of the cases in which there's consumer class actions, and the chances of getting those enforced, and how strong of argument does one have to oppose class certification. These are all issues that it's hard to really completely explore unless you have the ability to share information early on in the case. Everyone has different approaches. I think it's important to engage your opposing counsel in some of these discussions so that you could share information and do it in a way, and if you have to go through the mediator, do it that way, because I think we all have a duty to really give our clients real accurate information as to the likelihood of success in some of these issues in order to make mediation meaningful. And if you find there's a lack of information or a lack of willingness to share, that sometimes it raises antenna that make it hard to properly evaluate a case. So to me, this is an important part. If there's going to be mediation, cases have to be evaluated properly. The other thing where this also is important is a lot of times there is another party that's identified, I should say not identified in the litigation, but is a key player, and that's insurance companies. A lot of times there's insurance behind the scene that may be paying defense costs after a self-insured retention is satisfied, may or may not be involved with making indemnity payments. So a lot of insurance carriers will need to have a seat at the table at mediation, and a lot of insurance companies will need a full assessment of the underlying case before they're prepared to go ahead and make contributions for a settlement. Many times, while a party may want to engage in early discussion, if the carrier is the one ultimately funding any settlement or contributing to any settlement, there's a lot of work that needs to be done to get the carrier up to speed as well.
I'd like to jump in, too, with a question, if you don't mind. We have several lawyers that are attending this via webinar, and they are new to the concept of class action litigation, or they are young lawyers that are maybe just handling their first or working on it with a larger firm. So for their perspective and from a more basic starting point, who typically attends the mediation, gentlemen, on behalf of all the different parties? Who's usually present on day one of a mediation of this sort?
The class representative, of course, or if there's more than one, unless by agreement, the other side and the mediator have agreed that the class representative can appear by phone, because again, this is client-driven litigation. And then, of course, the lawyers who represent the parties. I do not always, if I have a case in which there are a number of law firms involved, I try not to bring everyone. Certainly everybody's invited, but I try to bring the key lawyers from those law firms who are part of the plaintiff's class group.
And would the feeling about telephonic attendance be the same at one of these mediations as it would be in a normal mediation, which is it's not an ideal situation, it's better to have them there in person, or is the dynamic that much different in one of these mediations that telephonic is viewed differently?
Well, personally, I think a client is more vested by being present. They have an opportunity to, not just hear, but see in how the process goes. I certainly am insistent on having a defendant representative there. It's the one occasion in which you have an opportunity to speak to the other side's client in opening statement, if that's used. It's not always used. It's easier for me as a class action lawyer to have my client present so the client understands what's going on, because it's not always as easy as consumers think to cobble together a resolution. And if they're there, they're vested. It helps establish adequacy, which is one of the Rule 23 elements, and ultimately, I want them to be able to testify what they observed and why they reached the result if they were called upon to do so.
Okay, thank you, John.
And this is Rod. We're also dealing with the mass action issue here, and so you're in a mass action. Uniquely, you're at a mediation anyway. The organization of that, because you're not going to have 1,000 people there, you're going to work your way towards the idea of who is going to be there, who are the leaders, who needs to be talking to try to negotiate for them, and there's got to be authority. So in order to have authority, there's got to have been a pre-mediation discussion to develop that level of authority. And so from the pre-mediation, I think what you're trying to do is identify the issues, the interests, the personalities, your leadership, and then you've got to, this last portion you see here, the agenda. Because if everybody, at least the lawyers going into the mediation, can know what this agenda is, then the lawyers can better lead their clients. And that is, it's such an important aspect of representation, and not just leadership, but representing your clients, that if you know what's going to happen and basically where things are, you can better lead, you can better formulate what you will need to get out of the mediation. And so pre-mediation is an integral part of both class actions. Mass actions, one thing I would comment on, because in mass actions, different than class actions, you have a variety of damages, different level of damages, different than a class action, which has commonality of those things. But in that distinction, many times you've got to be developing grids. You've got to be developing mechanisms of how you differentiate one client from the other. And before you can start negotiating, you've got to have an understanding of what those differentiations are. And so a lot of pre-mediation and mass actions goes to getting not only the plaintiffs to understand and to perhaps communicate to the defendants, but let the defendants know of what is, get their input on the differences, and then develop a grid that can be agreed on. Now that's a process in and of itself, but getting that grid differentiation, plaintiffs, defendants, defendants, plaintiffs, and then the ability to negotiate when you get to the mediation is an important aspect of that organization. But that kind of gets us into the mediation, and by way of your pre-mediation, you have what we call this issue sequencing, and that is what needs to be covered first, second, third. And again, some things are already in that what Steve was talking about before in terms of things agreed upon and those aren't agreed upon. I find that at least acknowledging those things are agreed upon, help build the bridge of trust and build the bridge with the understanding. And it's real important. Nothing is agreed until everything is agreed. And so we can begin to define the class. So we can begin to talk about monetary and non-monetary relief, because no one's going to get hooked on anything if we come up with a problem down the road. But I'd like for John and Steve to talk a little about this issue sequencing as we get into the mediation itself.
Thank you, Rod. Well, obviously the most important thing is to, before you can begin to address anything in mediation in the class context, is what is the consumer class that you're seeking to resolve claims on behalf of, both in terms of the composition of the class as well as the scope, a state class or nationwide class, or in dealing with multiple representatives from different states. Are you seeking to just resolve state classes in a certain number of defined states? Sometimes, if you have a multi-plaintiff class where each representative or group of representatives is representing various identified states, that can be easier dealt with than a nationwide class, which for one reason or another a defendant may not want to deal with. So that's certainly extremely important at the outset. Sometimes also I found that addressing the scope of the class by state can lead to discussions later expanding it across state borders into a nationwide class. Obviously, types of relief in that regard is extremely important. Is this a non-monetary class where you're seeking to advance certain important rights, but not through money, because perhaps money isn't possible? Or is it a case in which you're also dealing with money? I'll give you an example. I had a case involving a business that was overcharging consumers by small increments of money, where the businesses were representing that this was a tax or surcharge that they were passing on from the state. The amount of money per consumer was very small and only really triggered in an overcharge situation at some point in the year. Well, the administration of being able, to identify what consumer had overpaid, 21 cents, a nickel, depending upon what the surcharge was, would be extremely difficult, along with the administrative burden or cost of having to distribute that money to those individuals, because that money, eventually we found out, had not been remitted to the state of Florida. So, again, the focus in that case was non-monetary relief, because we wanted the conduct to stop, that is, to consumers to be charged if this was a pass-through or this was a surcharge to reimburse the defendant for what they had to pay to the state, so long as they gave clear notice to consumers that this was a charge being passed on to them that the company had to pay, then that was an important issue. So to the extent we had money that had been collected by the defendant, the only way to deal with that was a cypre award. So in large part, that was a non-monetary class case, and the cypre arose out of the injunctive relief component.
Steve, how do you see working into that type of relief? You've got a client who is obviously sensitive to the monetary end of it. There's this non-monetary end. Is there any aspect of that you could speak to in terms of client sensitivity on those 2 points?
Sure. First, on the monetary side, obviously, there's always issues with respect to the size of the monetary relief, the size of the potential class, whether or not there's the insurance company that may or may not be participating. Are they making a difference between certain types of monetary payment with respect to whether they're covered under a policy? Some insurance policies, for example, may not cover if there is a return of profit or return of monies paid to by the class plaintiffs, and therefore to differentiate between that with respect to damages that the plaintiffs are seeking that would there may be coverage for that would not be covered by an exclusion under the policy. So that's always an important distinction from a monetary perspective, and there's always issues that one must be sensitive to, because you don't want to end up walking down one path with how you describe your monetary relief that may affect coverage for your client. The second, on the non-monetary side, obviously there are certain practices that make up a company's core business, and you want to make sure that the non-monetary relief, does not open up doors for other claims. You want to make sure that it's done in a way that's all comprehensive. It's something that's achievable, and a lot of times, still keeping your client's core business in place. Sometimes there are issues with respect to, other ways of compensating class members. A lot of different cases look at giving plaintiffs coupons or other things of value, and that's always an issue too from insurance coverage perspective as to whether or not that is the cost associated with providing coupons, is that covered under an insurance policy as far as the cost associated with it. But it's important, I think, to look at and assess beforehand, and that's why, going back to some of our pre-mediation discussions, the worst part is to have certain non-monetary things brought up at mediation for the first time, while you clearly have, if it's a large enough company you're defending, they'll have in-house counsel there, but they'll need to run some of the non-monetary relief by the business people. So the more you could have some of these things flushed out in concept, the more likely that you're going to at least be able to have some meaningful discussion at mediation.
Steve, if I could interrupt for a second, this is Sandy Upchurch. I'm wanting to ask you a question that's been asked by one of our attendees. They were interested and intrigued by the Carlton Fields survey that you mentioned earlier, and the question that's been asked is, was that survey published, and if so, where?
It is published. You could find, I believe you could find it on the Carlton Fields website. It's also under classactionsurvey.com, www.classactionsurvey.com.
Wonderful. Thank you so much.
The report.
I think we have an attendee named Janet who asked that question. So Janet, now you can Google it while we're talking about it.
Sandy, can I follow up on a comment that just a monetary component that's
of course
also comes up in discussion? Obviously, hopefully, you've, in any class case or mass tort concept, you've sued a defendant that has got the ability to pay. That's all you should be a factor in determining whether or not to commence litigation, and also the type of relief. I found that in connection with damages, what can come up in discussions with the defendant is what I would refer to, or what I refer to, is a spillback. That is to the extent that monies are not claimed by the class. The question is, where does that money go? Is it divided pro rata among those who claim? Is it cyprayed, or is it given back to the defendant? All of those are extremely important questions. Obviously, a defendant is always looking at the amount of money it's going to have to pay, and that issue is front and center. I negotiated a settlement recently where we had an extremely large sum of money, but a very involved class of people who were following the case. We were pretty well certain it would be 100% of those claimants would claim, and in fact the claim form actually identified the amount of money that each person would receive. That was based upon the fact that we were able to do that with the information that the defendant had. In that case, no money is being returned to the defendant from the fund. In other cases, obviously, that's something you're going to have to deal with.
John, what's interesting about that, are you also familiar with, when you have a claims-made process, you come up with what would be a fair amount for each class rep, and then we all understand that in the class context, the take rate, you just mentioned 100%, which is an interesting dynamic. Many times that percent is well below 50%, maybe even below 25%, centering on 10 to 15% in terms of actual take. And yet on Steve's side, on the company side, their concern is the exposure. There are various mechanisms that I've heard of late, one even involving insurance, where you can purchase an insurance policy to say, look, we think the claims rate will be this much, we'll be paying that much, but we'll buy an insurance policy to cover the rest of it. Have y'all had any experience with that?
Yes, there's AIG has a product. I don't know if it's under the AIG brand. It may be one of their subsidiaries that will sell an insurance company a product so that the company can cap its exposure. So let's, for example, say that there is a common fund of $50 million and the company has a desire to cap its exposure at $30 million. There's an insurance company that, as I mentioned, AIG, that will sell a product that will, for a premium, will ensure that the company's exposure is capped at whatever the amount is, and then the insurance company is on the risk for everything above that.
Mm-hmm. Mm-hmm. Steve, have you come upon that? I know you represent AIG.
I do, even though I'm not speaking on their behalf today.
Sure.
But clearly AIG does have a product out there which I'm familiar with that is meant to kind of loss mitigation unit, that once you're aware of the claim and you want to have some insurance to help cover the post-litigation risk, especially when you've reached a settlement, there is a product available.
Well, and of course, all this has to do with, and as you go through the issues of what's the scope of the class, what's the definition, is it state, is it national, is it 5 years, is it, what is the amount of time involved, you get into notice issues that are, the type of notice that too will attribute to, the amount of take that's going to go on. How do you all weave that into your negotiations?
Well, obviously, I try to get negotiate the best notice possible. Traditionally, to the extent that, a defendant has names and addresses, then that's noticed by first-class mail. Sometimes a defendant in a consumer class on a consumer product doesn't have that information, so we negotiate both web or publication notice, but as more consumers get sophisticated, we go to a web-based form of notice. I was at a seminar that I spoke at last week in San Diego, and a notice administrator was publicizing its ability to use demographic information, to help better target who was in the class, so as to direct banner ads to web traffic that members of the class might be on, and at a very, very sophisticated level. So I think, again, as more people go to the internet, you're going to see more web-based use of notice, and courts have approved that under certain circumstances.
Mm-hmm.
So obviously, the best notice you can... Go ahead, Steve. I'm sorry. No, go ahead.
I'm sorry, John, go ahead.
No, I was going to say, obviously from the plaintiff's perspective, we want the best notice possible to ensure that class members get notice, and if there's monetary relief, that they claim in to that relief. I'm sorry, go ahead, Steve.
No, I was going to say, and also, it appears that judges are more attuned to looking at the appropriateness of some of these procedures, and I think it's important that both sides to this equation could stand before a court and say that it's fair and proper, and that once a resolution is reached, I think everyone's on the same side doing the best one can to make sure that some of these requirements are satisfied, and the federal judge could feel they're satisfied if they're a federal class action or state court. But these are all critical factors of the approval process.
You know, the one item that we have listed here under issue sequencing is opt-in, opt-out. And of course, opting in is, you know, can be part of the claims made process. Opting out is an interesting issue, because what a defendant is trying to achieve is finality. And you know how broad that brush can be to end this. Opt out, obviously, it puts a defendant at risk, and I guess there's a level. You know, but many times we negotiate. Well, what's the percentage opt out? If 5% or 3% or 10%, how do you see that working in your class action negotiations?
Well, hopefully you've negotiated a settlement that's fair, reasonable, and adequate, and as close to perfection as possible, although that's not perfect. So there is always going to be some segment of a class that will opt out merely because they don't want to be a part of a case or a class, and it has nothing to do with the nature of the relief or the quality of their claim, and those folks you'll never hear again. You have opt-outs sometimes who believe that they're far better off pursuing their own claim, but in the consumer litigation context, that's going to be pretty rare, because consumer litigation on the class basis by its nature is the aggregation of claims, which individually those claims would not be brought, because the dollars at stake are minor. Obviously, in dealing in a case where the dollars are much larger, then you might see more opt-outs. Last week at the judicial panel on multi-district litigation arguments in San Diego, there was a MDL petition filed by a defendant to transfer and consolidate opt-outs of a very large class case where the damages for each individual claimant was pretty large. That was rare. You don't typically see that. But, you know, where opt-outs, or where this issue comes up also, is if the defendant negotiates and demands a blow rate. That is, if there's a certain percentage of opt-outs, then the entire settlement collapses. In that regard, obviously, when those are involved, there's a concern that, you know, what you've been able to negotiate could disappear. At the same time, I tend not to be really concerned about that, because I'm always confident in the quality of what I've been able to negotiate on behalf of the class. And then secondarily, if it were to blow up for some reason, there's a certain level of opt-outs, then the defendant may have a bigger problem on its hand, because now it's noticed a consumer class that it was involved in litigation. These were the issues involved in the litigation, and it may face now exposure from a number of different consumers who bring issues to the table, either through contacting their local state representatives, or contacting the FTC or some other national or federal agency, or they're going to lawyers and filing lawsuits. So again, I'm not usually concerned about a blow rate of any percentage.
If I could interrupt you guys,
needs to
Oh, I'm sorry. I was just going to interrupt you all again. We got a great question, and it's a little bit off topic, but I think it's important to try and answer these as they're coming along. It shows people are listening, right? The question that we got relates to insurance coverage, which is obviously quite topical. And the question that's been asked is, in the years that this gentleman has been doing class action work, he says inevitably he leaves these mediations wishing that he had better understood the insurance issues going into the mediation. And his question specifically is, would the panelists recommend the plaintiff counsel hiring insurance experts as consultants on that issue, or what else would you all suggest that plaintiff's counsel do to address the impact and import of insurance coverage in advance of the mediation?
Well, I'll dive in first to say this. This goes back to the need for pre-mediation, because to the extent that that question is relevant to the discussions, it ought to be addressed pre-mediation. I'm going to kind of get out of the way and let John and Steve discuss it, but that really needs to be one of those issues that's inquired about, brought up in a pre-mediation context, so when you get to the mediation, you can be able to deal with it effectively.
That's great.
John, I apologize.
No, Rod, well, there are a number of local rules of U.S. district courts which require certain disclosures, and in the middle district, in your initial disclosures, there has to be an identification of whether there's insurance at issue. Also, I have no problem asking the other side whether there's insurance, or having the mediator ask that. For one of the reasons is that in connection with mediation, if insurance is in fact in play, then you need somebody who's a decision maker from the insurance carrier. Sometimes that requires the carrier retaining independent counsel to provide advice, or it requires the defendant's counsel to write an opinion letter about the exposure. It can slow the process down, but obviously it's a very important component. So I am always very aware, and probably more so too because I at one time represented insurance companies as a part of my practice, so I understand how general liability policies work.
Steve, do you want to jump in too?
Sure. From the plaintiff's perspective, and I haven't been on the plaintiff's side, but I could tell you that, one, John is correct. The federal rules usually require a defendant in initial disclosures to disclose whether or not there is any insurance policies that may come into play. Also, there's a Florida statute. If a proper demand sent to a carrier, they not only have to disclose the policy, but any coverage issues that may be relevant to the claim. I think it's important, depending upon the who's going to be making the ultimate decision, and many times both the carrier and the defendant have their interests aligned, that if a settlement's reached, and this kind of goes to the opt-out discussion, part of what they want is a complete piece, a bar order, that's going to bar other claimants from filing any copycat claims or making any similar claims. A lot of times an insurance company will say, I value it at X dollars, or I have these coverage issues here, but I'm willing to make a compromise with my insurer to contribute to this. But once I could put this money up, that's it, and I'm going to ask the insured, the defendant, to give me a release from this claim. And insured, you have to be on the hook for any opt-outs, because I'm not going to continue, paying money for defense costs associated with any opt-outs. If you want to buy a piece, let's buy a complete piece. So at certain times there's a lot of insurance issues that come into play, both from the plaintiff's perspective as far as making sure counsel knows who ultimately is going to be making some of the payments and what their interests are. And from a defense perspective, as I said before, there's some critically important issues dealing with what type of ultimate release you're obtaining, but also whether or not some of these payments would be treated as payments that are covered or payments that are not covered. So all this is important to get a true understanding of where the insurance company is with respect to the claims that are being made.
Great,
Stephen,
thank you.
to tie into what Steve just said, and I'm involved in one right now, we're going to the mediation defense counsel, and Steve, I know you've done this and others, there are times where there are coverage issues. And so we'll be at the, and again, through pre-mediation, we get to the table knowing that there's going to be coverage counsel there on behalf of the insurance company, coverage counsel on behalf of the business, the defendant who is defending. And and for the plaintiff to know that and be sensitive to that, I think is really critical to the opportunity of getting a successful result.
And
Great.
I can tell you, we just settled a large class action where I happened to be representing an insurance company. And you're right, there were significant coverage issues, and the only way the settlement was achieved is there were contributions made by the insurance carrier as well as the insured defendant, because there was a real question of coverage, and both had, and that case would not have been settled without contributions from both, but there was that side negotiation that the mediator had to play a critical role in trying to get sufficient monies put up on one side of the table, but being made by both the party and its carrier.
Right.
Wonderful. I am the one that is probably holding us back from actually moving forward, so I apologize for my delay tactics, if you will, but we do have about 20 minutes left and quite a lot of information to cover. So I think our next topic, do we need to cover notice, Rod? Is that what our next topic is?
I think we can go beyond notice. Administration, I think, would be helpful, and then to get into both incentive award and fees. But administration, in recent years anyway, there are some known companies that do this. Sometimes it can be done in-house, but most of the time it's outside. Do you find that that's really much of an issue between plaintiff and defendant, or can you usually come to somebody? If we can agree on everything else, is administration something that can be taken care of fairly easily, guys?
Rod, you're right. There are a number of very good administrators out there who handle both the notice as well as claims administration, and that's expanded over the course of years. 20 years ago, certainly the field was far less crowded. That's generally never an issue. That's something I've always been able to work out with the defendant. Cost, I think, is an issue for the defendant because the defendant always bears the cost. There are some cases I'm aware of, none of which I've been involved, in which the common fund established in a settlement is the source of for paying for administration. I don't negotiate that. I've never had to worry about that. So I'm very sensitive to the fact that the defendant wants to maintain a lower cost, but at the same time I'm very concerned about getting a very experienced administrator to handle both the notice as well as claims administration. So I think it's something we've always been able to work out.
Steve?
Yeah, there's unfortunately sometimes the costs, depending upon the size of the class and the method of publication, can vary and be expensive. Quite often, even though some clients want to try to do it themselves, I think unless they really have the systems in place, it's better to use an administrator to do it. And one of the issues that does come up, depending upon what the terms of the settlement are, is whether or not there's some proof required by a member of the class who submits a claim, and whether there is a methodology in the settlement agreement for the defendant to object to making a payment to a particular member if those conditions aren't satisfied, and what is the methods of doing that, and how do you have that particular class member's dispute be resolved. Those are all important things that are part of the administration of a class and part of the negotiations of a settlement.
I think the next two portions are where we really get into some important issues, and I want to focus on it by way of the issue sequencing we just talked about. It is important that these next two items are right where you see them. We need to first define our class, talk about non-monetary and monetary relief, deal with opt-ins, opt-outs, notice, and administration, and then we begin to deal with, okay, so what's the value of an award to a class rep, and then after that, then at that point deal with attorney fees. Do you all wish to speak to the incentive award? Is something we can kind of work through relatively soon, but it's an important thing to take care of before you talk about attorney fees. How do you all handle that?
It's something that I handle right at the inception of any representation of a potential client in a class case. One of the things that is so important is the issue of adequacy, and that is that the class representative not seek or receive anything more than any other member of the class. I'm very upfront with that. I want to make certain that that's the expectation, that's the understanding. I do tell them that on occasion courts can award an incentive award for a class member undertaking a case, but it's small. It's a small amount, and it's representative of the amount of time that an individual will take to get involved in the case. So in connection with the incentive awards, when that issue is negotiated after all the essential elements of the settlement have been reached, I am very mindful of whether the case was a 1-year campaign or a 7-year campaign, whether or not the class representative was exposed to having to attend the deposition, the amount of discovery the class representative was forced to endure, as well as the amount of litigation that took on during that that period of time that the case was pending. So I'm constantly monitoring the case law to ensure that my understanding of what courts will award is the same. It's updated. So I take all those factors into consideration when I have that discussion with the class representative at mediation, that this is what I think we should pursue, and those negotiations, begin at that time. Again, with the understanding that ultimately the court needs to approve it and could award nothing, although I've never had that occasion. The other thing, and this is something I never even thought would be an issue, but it's come out of some case law in the Ninth Circuit, where the class representative's award was tied specifically in writing to supporting the settlement. And in those cases, out of the Ninth Circuit, or they had gone up to the Ninth Circuit, the court found that the class representative's motives or interest had been compromised by that kind of an agreement, and never tie that incentive award to that condition. And again, until I read those cases, I wasn't even aware somebody else was doing that.
Mm-hmm. Steve, on the incentive award, any input from the defense side?
No, you just usually that is done as a major stumbling block. If you're able to get everything else in place, those awards are, at least by experience, are not a major issue. It's more the monetary relief to the class, and maybe, depending upon who plaintiff's counsel is, the attorney's fees, and whether how much of that's equated to monetary and non-monetary relief.
The one aspect of this that I want to shift a little here, because this seminar is not just on the class action, though that's where the primary discussion is, but also focusing on mass actions. And there is no class rep in a mass action. Everybody is on, I'll say, similar footing, maybe different injuries, but on a similar footing. But the dynamic that the attorneys have got to deal with is the global negotiation and the individual negotiation. And there's a sensitivity on the plaintiff side that they can't be negotiating against their own clients. And so the idea of negotiating an overall global number with the defendant, but in the context of some format. And this is where that grid I talked about earlier becomes important, so that the mass members understand where they are. Now, many times the negotiation takes place, okay, this is what the overall number is going to be, go about getting everybody on board. As long as you get 95, 98%, you're okay. If there's 3, 5, 10%, maybe we can still deal with that. There's that blow-up provision that John mentioned earlier. But coming back in a mass action to be able to get clients on board sometimes is a second mediation. Sometimes is a mediation among the plaintiffs. Where we said, the defense says, look, I'm not going to pay any more. You get it under this tent, and we've got it. You better get everybody. But if they're maybe 5% out, we'll live with that, but we'll have the discretion on that. And then the plaintiffs have got to go about a mediation where they have to deal with getting everybody under the tent. So just another dynamic. I don't know if you all have had experienced that, but that's certainly on mass action, something's got to be taken into consideration.
Gentlemen, we're at about 1 o'clock, and we have so much more to cover. Should we move on to quickly get through some caucus issues and some post-mediation issues?
Sandy, can I back you up? Because I think there's one aspect, that attorney fee and cost is an important one. And as much as we need to get in the others, that too becomes many times a mediation of its own.
Sure does.
And John and Steve, can you speak to that before we move on to the post?
Yeah, let me just speak on the issue of sequencing again. I've had any number of defendants or their counsel try to get from me in advance, oh, how much is the fee? What are you seeking as the fee? And I've never, ever given in to, that solicitation. The attorney's fee is an issue confronted only after all the essential elements of the settlement and the incentive award have been reached. And only then is it an issue for discussion. I simply will not engage in that discussion. I believe it to impact the fairness of the process. And it's kind of interesting. A few years ago, I was involved in a case. In fact, Rod, it's one that you mediated. And it was an extremely large class, probably the biggest in the history, I think, because it involved everybody over the age of 16 for about a 9-year period. And objectors came forward and claimed that because the attorney's fees had not been negotiated at the same type of the relief, that we had engaged in some kind of unethical behavior, which was just mind-boggling. And there were a number of professors who had signed a paper of sorts which took the position that the defendant's focus is always on ultimately what's going to cost, so you should negotiate the fees up front before talking about the relief to the class, or do it at the same time. That position has never gotten traction. It's not been the accepted view in the case law. It's always the issue that I leave to last. And I've always been able to... Oh, go ahead, Steve.
From a defense perspective, I never bring it up either. I think it's unethical and improper. And in fact, from my perspective, plaintiff's counsel, if everything else is agreed to, I find they're more difficult for them to be unreasonable in this process and to put them in the position that they're going to not complete a settlement because they've been unable to reach a fee agreement. I think there's a fair process in these discussions, but I agree with both Rod and John. It calls into question the whole process if it's discussed anything or at any time other than at the end.
And I think that we can leave this with this. There are parameters by which attorney fees are measured, and you need to follow the case law that gives you the license to go one way or the other. Is it a percentage of a common fund or value? Is it a lodestar with a multiplier? Is there some consideration of statutory entitlement? Those are issues that need to be identified to be the measuring tool as to how you're going to go about the negotiation. When?
Right, one other thing, if I could, as part of this whole process of dealing with the mediation and sequencing, and part of it, someone asked the question, do you get someone with knowledge of insurance there? The one thing that we didn't discuss, are there other types of claims that are similar based upon the underlying facts that would not be part of a class action settlement? And I've had several cases recently which has made this process difficult. One is the fact that there is major bankruptcy in which the creditors committee and senior lenders have made certain claims and would not be involved in a class action settlement of the equity holders. And there's some instances where a court has appointed a receiver to marshal the claims of certain members of the interested party, and a lawyer has filed a separate class action. There's a difference between creditors' claims and equity holder claims. So sometimes there's a lot of competing issues that are part of this. I find most companies, when they're defending, they want to get a sense of what it will take to buy a complete piece. So not only is it dealing with the insurance company, but it's also dealing with other potential claims that may arise out of a common nucleus of facts that may not be part of a particular class action settlement, but other related claims based upon those facts. So sometimes this process turns into a multi-day process in which a defendant will insist on trying to get everything settled, not only the class, but other claims by third parties.
That kind of gets us in, and Sandy, I think we can probably go down to the post-mediation through the caucuses, and caucuses will take place joint and separate as are needed. But I think what Steve has gotten us to is this post-mediation, and that is that if you set your agenda so the expectations are reasonable, the question is, what are we going to accomplish in day one? Do we need day two right after that, or do we need to take a break of 30 days? Maybe the insurance people need to hear something, and then maybe they need to take a break and reevaluate based on what they've heard. So there's, in the issue sequencing, there's also a meeting sequencing. And so I just got finished with one where we knew we weren't going to get it done that day. We made the progress we needed to, where insurance people are evaluating, and a company is evaluating, as well as the attorneys on the plaintiff side appreciating now some of those issues, and take a 30-day period, and we're coming back the end of April to get back started. But I think in addition to just meeting, one of the base values of post-mediation is you can get on the telephone. Now, the telephone works because in the world of confidentiality, am I talking to the plaintiff today, or am I talking to the defendant today? That's confidential. And so there are some aspects of the confidentiality that help in post-mediation by telephone, as opposed to being in the same room where you know where the mediators come out of a room to get into the other, so you know that he's bringing a particular message from a particular side. But the phone mediation, strategically placed and confidential, can really assist in keeping a process alive, keeping it going, never quitting, and reconvening in person if and when it's necessary. How do you all feel about post-mediation?
I think it's, from my perspective, the only way cases get resolved is by continuous communications. I often say I will proceed with the case as if there's no chance of settling, but I'll proceed with settlement as if it's the most important thing to do. I separate the two. I'm as aggressive as I can be when it comes time to defending a client and doing it, vigorously and with zeal. But I'm never opposed to continuing having communications. And to me, a good mediator is someone who will keep people involved in the process. Many times I've been involved where we've had early mediation and it wasn't successful, but several months later we've come up with ways at least to minimize the issues, which leads to maybe a third mediation session. I've had one case where mediation lasted over 2 years. We had 8 sessions, but ultimately we ended up getting it resolved. and it takes time. Issues were crystallized, discovery, legal issues were ruled on by the court, and people, in some respects, found it was better to have it resolved by your own hands than totally relying on the legal system. But I think it's important to keep the dialogue going.
Well, and I appreciate
absolutely. And there's sometimes they're just... Go ahead, I'm sorry.
No, go ahead, John.
No, I was just going to follow up. Sometimes, you know, if you've got several days set aside or one day, you simply can't address all the issues. And that process that continues, whether it be by continued in-person sessions or phone or a combination thereof. You know, to add my own war story, I think we had a mediation that went 21 separate mediation sessions, some multi-day, over 2.5 years. And that's putting aside the countless number of phone conversations with the mediator and with the mediator's assistance on the other side. It's once you get parties vested in the process, then, you know, I keep hammering to get that fair, reasonable, and adequate result.
Which kind of gets us, I know we're running close to being out of time, but we've got the use of the ethicist and a term sheet. I know those are details, but I think they're important details. John, can you speak to the ethicist, and then Steve, can you speak to the term sheet? John?
Yeah, this was, I had a mediation once, and we had certain issues that both sides were severely entrenched into their respective positions with an apparent no way out or bridge. And what the mediator did in that case was to retain his expert to help us bridge those issues, to deal with both a significant substitution or substantive, not constitutional issue, as well as a ethical issue. And by bringing this person in and having this person, in essence, kind of give us a flashlight out of the cave, we were able to resolve. Actually, it was one of 2 different cases, and then that case withstood scrutiny both at the lower court and the appellate court. I had never done it before. I haven't had an occasion to do it again, but again, it's a way in which parties that are so entrenched in their positions can bring in a expert to help bridge the issues.
Very good. On the term sheet, Steve, can you speak to that? Because I know that's the agreement.
Well, the difference in a term sheet and actually a settlement agreement, I always attempt to have the parties, at least my clients, think through the critical terms of a term sheet before mediation. Yeah, obviously, I don't share it with the other side, but I think it's important to kind of walk through the different terms of what you anticipate the settlement will look like. You know, how would you describe the class members? How would you describe the form of consideration? What type of proof would be required? What type of non-monetary relief, if any, would you consider? What's the appropriate claim process? What would you look towards as far as the proof of claim form, and what type of broad-based release are you looking for in the settlement process?
If I could jump in, I'm sorry. Go ahead, Steve.
Use that as a basis for your ultimate settlement agreement, which you're going to file for preliminary approval with. But it forces both counsel to have a good conversation with the client as to what we're looking to as part of the end game in the mediation process. And especially if you have insurance company involved, you want to make sure they're on the same page as far as what are the terms they want to see covered in a term sheet. And then you want to make sure there's no misunderstanding with the mediator and with the opposing counsel. So quite often, if we're able to have a term sheet done at the time of mediation and filled in, then we do that. If not, we try to get one done within 24, 48 hours thereafter.
I was just going to jump in, Rod, if you don't mind, and say I think
Sure.
that doing a term sheet in advance is so wise because especially I would assume for defense counsel and for the insurance companies, and because there are certain terms and provisions that they want in there and they want certain specific language. That language is going to get forgotten, left behind, overlooked, or something if it's done that day or in the days that follow. If there is a considerable period of time in advance, they can get together and start looking over what those required provisions are. It's just less work at the tail end, and you're more prepared at the tail end. Less panicking moments, less overlooking things, less mistakes are made. So I think that was, I think that's spot on, is doing things in advance for the term sheets, for sure.
And with that, I think it brings it down. The affidavit that sometimes a mediator does is simply in support of the arm's length, non-collusive nature of the mediation. I have given affidavits in support of what has been done, the way it's been, and not to get into the substance, but just to talk about the fact that it was arm's length and non-collusive. And there have been times that I've testified where I've been subject to the cross-examination of an objector or even the court wanting to know what happened, of course, with the approval of each side and exposing the process. So the mediator can help in support of a class action.
Rod, I don't know what you want to do. We are pretty much out of time. We are exactly at 1:15, and I'd like to go ahead and, if you don't mind, maybe give everybody the webinar CLE information, and then
Sure.
anyone that wants to jump back in and listen to the confirmatory process. Would that be okay with you? I'm going to take that as a yes. I take silence from my husband as a yes, so I'm going to take that as a yes. Can we get a puppy? Dead silence? Yes, we're going to get a puppy.
Actually, the confirmatory discovery is really that's in the word of post-mediation, a class action will end subject to confirmatory discovery. And so Steve and John, am I right about that?
Yes, sometimes in the mediation process, there's a need to confirm certain things that have been exchanged because depending upon where the case is, there may have been an issue not ventilated in discovery. There may be an issue that's come up in connection with, say, a damage analysis and a need to take discovery, whether it be request for production in interrogatories or a combination with a deposition. I have recent experience in the last couple of months of, again, having a defendant run a damage analysis based upon information that it had that we did not have, and a need to explore through the individuals who conducted that the accuracy of what the number ultimately was. So that can be a very important part depending upon the nature of the case and the nature of the settlement.
Wonderful.
Sometimes non-monetary relief may play into when a particular class period may end, and there may need to be confirmatory discovery about in fact, implementing that non-monetary relief to ensure that it's been done adequately so the court can properly determine when the class period is over.
Wonderful. I'm just submitting a reference to all of our guests, a chat to our entire audience that, as you can see on the screen, we have our Bringing Class Action and Mass Action CLE information online. The Florida Bar course number is 1401476N. Yes, we will take your calls afterwards and give you that Florida Bar course information, but we will make fun of you if you call us and ask us for it, because we just inevitably we get one or two phone calls afterwards asking for it, and we do have to make a little bit of fun of you. But we will gladly give that.
Make fun of your husband.
Yeah, that's just turnaround is fair play, Steve. That's all that is. But I want to thank all three of you. I think today was extraordinarily well received. I can tell from the number of questions we got in advance and from the level of interaction we got from our audience while we were talking. I can tell if people are attentive or are not by the dashboard that I've got, and they were all plugged in the entire time. Thank you all so much. Steve, Rod, and John, I could not have
Thank you, Sandy.
imagined a better a group of individuals to handle this very complex topic. I hope that you will join us again for another maybe follow-up on this topic, because obviously it's something that's growing. We were talking earlier about I guess you call them security breaches or informational breaches, and those are happening more and more, so I think we're going to be having more of these types of causes of action long into the future. So please take note of the Florida Bar course number 1401476N, and please note that we do have an April webinar coming up with Michelle Jernigan. We already have about 150 registered. Whether you want to know it or not, you need to know what's going on at your client's brain during mediation, the good, the bad, and the ugly. So please join in. Michelle will shed some light on that topic for us. She is very well prepared, has written several articles about this topic, and I'm very excited to present her to you on April 17th at noon. If you have any follow-up questions, please feel free to call Steve or John or Rod, or email them, and we will get those questions answered for you. Thank you, all of you. We at Upchurch, Watson, White, and Max are so pleased you were able to join us. And from all of us at Upchurch, Watson, White, and Max, to all of you, we say ciao for now. Bye, everyone.